Your Honor.
Yes, Your Honor.
And that's, is it Philippe Din?
Yes, ma'am.
25CR107878. Good morning.
Morning.
All right, this is time set for your Valdez Jimenez hearing. I'm sure your attorney explained to you what the case law means and what we have to do here today to determine a bail amount.
Sure.
Thank you. And Ms. Rose.
Thank you, Your Honor. And I understand at the very outset of this, the state is going to be asking for a large amount of bail. The state is going to be asking for $750,000 in monetary bail, conditioned on high-level house arrest and no contact with the named victim. And then no contact would be a no contact through third parties, no contact directly from him to her. These are the reasons why, Your Honor. This case is the epitome of a domestic violence survivor. Since the inception of their relationships shortly after they got married, this has been a verbally abusive relationship. It's been everything that she has done in the past held against her. This is a very mental traumatizing, no one will believe you. If you call the cops, no one's gonna believe you, because I am the cops. They both work for Metropolitan Police Department. It's fears of, I'm gonna ruin your career if you report this. This has been a very traumatic experience for a domestic violence victim. The tactics that have been used throughout the course of this relationship makes this literally the epitome of a domestic violence case. So when I argue about cases that something happening from 2023, these are the reasons why it's such a traumatic event, even though it's from 2023. And as Your Honor, I know Your Honor has read the Declaration of Arrest thoroughly. It starts in the very violent episode starts in 2023, where he is caught on video dragging her violently into a bedroom, where then she sustains injuries due to the incident in 2023. Then you move on to 2024, where it's caught on video as well, another second-degree kidnapping, where she is forcibly trying to leave. He is pulling her, pushing her, flips her over, and drags her back into the bedroom. Again, these are also in 2024, after this incident, is corroborated by a note that was shared from the defendant to the victim. In the Declaration of Arrest, Your Honor, I know that you've read it, but it's basically, please don't leave me. I'm going to do these things, including working on a safe place for Helen. There will be no unwanted touching or any physical injury whatsoever unless given the okay. No talks of career ending one's career or ending one's career. Manipulation or coercion is not acceptable, and if one wants to do one thing, they are able to do it. Free movement is paramount. We will be able to leave and go throughout the house regardless fighting or not, etc., etc., etc. He even says, as far as abuse, we are on record that everything will be reported. Helen will not be Phil's safe place anymore and will not protect him. He will be on his own. If actions are taken, criminal IAB and family will be involved. Videos and photos are listed as evidence. He understands that these videos exist. He understands that this is what he's done, but they're trying to work it out. She wants to stay with him. This is a domestic violence relationship. Then mom and dad move in, mom and brother move in, and the violent episodes stop for a period of time. So then brings us to 2025. There had been allegations, obviously in the Declaration of Arrest, of allegations of uncharged events that Your Honor has read about, and I know you're going to take those into consideration as well. But that brings us back to December 7th of 2025, the incident where she's talking about a purse that was purchased, and there was violence that occurred on December 7th. And then that brings us to December 8th, where this all comes to fruition, where they get into a fight, she leaves to get errands, finds out that he's cheating on her, she's trying to get his phone to look at text messages, fight ensues, where then he won't let her leave because now she's done. She's completely done with this relationship, and he knows it, so he wants to prevent her from leaving, grabs her again, and that's the last time that the defendant will be able to touch this victim and violently attack her. Your Honor, the issues after, when she finally gets to leave the house, he texts her and he says, please answer. I need to know whether or not I need money. And then she stops sharing her location because, again, she's finally had enough of his abuse. He keeps asking, can you call me, please? My job, please, I need to know. I need to know if I need to tell my dad, because if I go, he needs to know, please. You probably said everything because you don't lie, but I need to tell somebody. I've never ruined your career, something that was a dream. I'm not home. Please, you and Dex take it home, and I don't want you gone somewhere not safe. These are all things I did something. I'm sorry, please. Are you going to tell the cops? That's exactly what the gist of those text messages are. Why I'm asking for that amount of bail is the statutory factors. The likelihood of conviction in this case is very great. I understand that defense has evidence that they are going to want to present that may or may not contradict this, the version that we have that the state's alleging. However, this case is, again, the epitome of a domestic violence survivor that has been tormented for over, at this point, 3 years. After this is all transpiring, the state is concerned now. I cannot prove this beyond a reasonable doubt yet. The state is concerned that while she was trying to pull up information and evidence, somebody was logging into her iCloud account, attempting to get into her iCloud account. She can no longer access the Ring video. I understand that defense is saying that they believe that she locked him out. As she's trying to get the evidence for the police officers, she's getting logged out. She's not able to, as someone's trying to log into her iCloud account, there has been overwhelming evidence that the defendant knows that every single time she's about to leave, he tries to take her phone, her iPad, her laptop. Also, he can try to delete the evidence that happens. Also, it's preventing her from reporting. These are things that, put together with his past allegations and what he was doing after, when he realizes that the cops are now involved, it's concerning for the state that there could be a potential for more of destruction of evidence. Obviously, we've done everything that the Metro has done everything they could try to do to preserve, send preservation letters, but that only can go so far. So with that, Your Honor, the state is very concerned about the safety of the victim, the safety of the community. The allegations that are contained in the declaration report sends complete high red flags to the state regarding the allegations of the threats to commit suicide. Obviously, we all know how domestic violence works. When there is no hope and somebody thinks that this is it, that is the high call for a murder-suicide. When it comes to domestic violence, it becomes extreme concern for the state releasing the defendant to the streets. Obviously, the state is asking for the high level of house arrest as well as a no contact in the event that he can post any type of monetary bail, but the state is gravely concerned with not only the safety of the victim, but the community as well as the defendant at this point. But with that, Your Honor, I'll submit it.
All right, Mr. Goodwin.
The state made much mention about overwhelming evidence and high rate of conviction, yet overwhelming evidence seems to consist solely of her word. That's what it is. We don't have a lot of corroborating evidence. We do have those 2 videos, but the context of those videos is entirely missing, only provided with her statement. But I think it's important that we point out one thing. The state spent the majority of their time reading the Declaration of Arrest, going through all the facts, and trying to paint this picture based on those facts, and completely stayed away from the requirements that Valdez-Jimenez asked us to look at. When we take a look at just those facts, there is no real justification to detain Mr. Dinh. They cannot justify the detention of Mr. Dinh. He has been living here, he owns a house here, he has family who come and friends to support him. So he's got community support and people willing to speak on his behalf. He has no prior criminal record, he has served as an officer, he has done his job well as an officer. He has not been disciplined to my knowledge, he has not been someone who's getting off of that. So this is an individual of good moral character, in good standing in the community, strong ties to the community through the house, and his parents and everyone else who lives here, and somebody who has never been arrested before. Furthermore, we are not objecting to staying away from the house and allowing this to go out because the innocence of Mr. Dinh, we believe, is not in question. Because when we're talking about overwhelming evidence, what are we talking about? We're talking about witness reports, we're talking about simultaneous reports, we're talking about things that would be instant disclosures. We don't have that in this case. We don't have witness statements saying, yeah, I saw her coming to work with bruises. We don't have statements of her putting on lots of makeup and saying, oh yeah, I just bumped into the door. These kind of real typical domestic violence cases where they're trying to cover it. We don't have any of that evidence. What we have are videos out of context. We have a shared note, and that shared note's an interesting note. Your Honor, I have a shared note with my wife, and I challenge anybody in here to tell me who wrote what. I challenge anyone to tell me. There is no history to say who wrote what on any of that note. There is nothing in there that would suggest that one person wrote or anything. So having this shared note doesn't really establish anything. When we're looking at those text messages, again, we don't know the context or what was happening in that. Because what we have are two very different accounts of what happened here. What I will say is, there is no record of Mr. Din ever being suicidal. Nobody's ever mentioned that. Nobody's ever said that. Nobody's ever expressed a concern about him being suicidal. And yet it's coming, again, from the one person who has a lot to gain by him doing this. And what does she have to gain? She gets the marital assets. While he's in custody, she stays there, she gets to stay there, and she gets to gain from that. So, Your Honor, the only evidence that we have so far in this case is really testimony, out-of-context videos, and other things that we cannot directly attribute to Mr. Din. That's insufficient. On the other side, we have a person of good moral character, a person who has never been in trouble, a person who was a police officer, a person with ties to the community and family to the community and people willing to speak on his behalf. With that, Your Honor, there is no justification for detention. What we are requesting, given the seriousness of the charges, and given what Mr. Din can realistically pay, is a $25,000 bail. We understand that monitoring is going to come along with any charges of this, so we're not going to contest that. And of course, we have no issue with the no-contact order. A restraining order is already issued as well, so there's a double layer of protection. Most importantly, and I think this also goes to credibility, Ms. Din knows exactly what she needs to do if she feels in trouble because she did it this night. Why she didn't do it the other years before, we may never know. Why she didn't contemporary report, but she did this time, we don't know. Because these allegations stem for years, allegedly, without anybody else corroborating anything. So, Your Honor, at this point, I don't think there is enough to justify any detention of Mr. Din. The only person saying he's suicidal is her. There is nobody else that can say that that happened. He has no mental health diagnosis, no mental health issues. There is no depression, there is no anxiety, there is no bipolar disorder, there is none of that. So to hold him out of that would be unjust. What he can realistically pay for his bail is a $25,000 bond. He will not go back to that house because, again, he has strong ties to the community and other people that he can stay with. But to hold him in detention, to deprive him of his liberty interest, strictly based on things that she said, is inconsistent with Valdez and Menace, and it's inconsistent with fairness, just basic fairness. So what we're asking for, Your Honor, is a $25,000 bail. We're fine with whatever monitoring the court believes is appropriate to ensure the safety of the community and the alleged victim, and we are fine with a no-contact order.
All right, Ms. Rose, do you have a response to any of that?
Your Honor, I would just like to remind the court that this is, as we are speaking, there are certain pieces of evidence that are going to be also presented to this court by the preliminary hearing date. Obviously, as of the fact state in the declaration of arrest, we can go off of that, but evidence is still coming forth. So as Mr. Goodwin's saying that we don't have witness statements and things like that, I do believe that those types of statements about bruises and covering up bruises have been made. Whether or not the people will come and testify to that is another thing. However, I just want to remind the court that Valdez-Jimenez doesn't take away the statutory factors to consider, but also in addition is going to have the court consider the means of financial means of posting that monetary bill, as well as the safety of the community and flight risk. So when we talk about the evidence that corroborates that, that is why I'm hitting so hard. And of course, I disagree with Mr. Goodwin that the evidence presented is just her words. I don't know what kind of context you can be taking outside of what the video show, as well as the text messages. I believe the text messages are very much in context, and it's very hard evidence to dispute. So with that, Your Honor, I'll submit it.
All right, and both of you brought up Valdez-Jimenez, so I just want to really just state clearly that there's no constitutional requirement that bail must be in an amount the defendant can afford. The the consideration is essential to determine the amount, right? And you brought up that point several times, Mr. Goodwin. I just from the outset want to state that. But you know, I will consider it's essential. It's very essential to determine the amount of bail that will ensure his appearance and safety to the community. That's what the bail is for, is to ensure his presence and to protect the community and the victim in this case. After hearing and seeing the videos that were presented, there is going to be a lot that's at issue to discuss when it comes to determining the facts that can be determined in the case and what is going to be relevant to the charges and what is going to be proven either at trial or if there is going to be a preliminary hearing. But for this purpose, I had to look at the evidence, listen to the arguments, consider his length of residence in the community. We did talk about his history of employment. He has relatives here, his reputation, that there's no prior mental condition that we are aware of. There's nothing like that that's been brought up. I know there's allegations from the state that there's you know, a concern for suicide or murder or anything like that, but I believe that there's just the heightened climate right now because there are other cases that have hit the system like that, and I'm not going to take that into consideration unless there is some kind of evaluation or some kind of other determination that he is suicidal or anything like that. So I'm just going to really look at the NRS 178.4853 factors, the times of community, the likelihood of his return, and the state has shown by clear and convincing evidence that there is a bail amount that should be applied to this case because of the nature of the charges and the likelihood of some conviction to some of these charges. That's not going to be determined today, but the bail amount will be $150,000. He will have high-level electronic monitoring and no contact with this victim. There will be, then you said there's already a restraining order in place, so there's another layer of protection for the victim. And I believe that he has family here that he's going to, if he does make the bail, live with. I want to make sure that there is a forfeiture of weapons clause and that house arrest has a special note that they must go and look through the house wherever he's going to be staying if he's able to make the bail, and that there are no weapons there, and that there are no weapons to be brought into the house at any time, and that those will be the conditions in place. Would you like to set this for preliminary hearing in 2 weeks?
Brief court's indulgence, Your Honor, just for clarification, if he cannot make that bail, we could show that they attempted to. The court entertained lowering that number.
At a later date, you're saying?
Yes, Your Honor.
Yes,
If we
if
take
you file a
efforts to
motion.
pay it and cannot.
If you file a motion and then give the state time to respond.
Understood, Your Honor.
Okay,
Thank you.
December 24, 10 a.m.
the 24th. We're open.
Yeah.
We just opened it?
Yeah.
Okay, good. We just opened it for the preliminary